Good morning and welcome into Right Now. You're watching us here on the CBS 8 app. Today is April 30th. It is Thursday. Yes, we are almost there. I'm Chris Gros and joined as always here by Jack Hull. Jack, one of the stories that we highlighted for our viewers just before we ended yesterday was a landmark Supreme Court decision, one that I don't think a lot of people had on their schedule. In fact, correct me if I'm wrong, this was something that we had last heard arguments on about 6 months ago.
Yeah.
I believe it was about a half year ago.
Yeah.
And it just sort of came down out of nowhere.
Of course, we've seen more notable Supreme Court rulings and arguments and the likes of the matter in recent months. So, kind of one that maybe just kind of fell under the radar. I know we'd be looking at different news wires and different, all of the news services that we use on a day-to-day basis, and you'd see it. Maybe like, no one reads physical newspapers as much anymore, but it's, this is, way past the front page kind of thing. It was like that kind of news story, but the implications were massive. Yeah. And yesterday we really saw it come to a head in the immediate and the long-term impacts are starting to come into picture right now with long-lasting consequences that could go into well past the next decade.
Mm-hmm. Yeah, no, and I think for a lot of people, again, who have heard about this ruling, we're immediately thinking about the midterms. For all intents and purposes, this does not look like this is going to have an impact on the midterms, but we are going to go through the analysis.
Yeah.
To see, it might, exactly. That was the initial. Now we're maybe hearing differently. So we're talking about, of course, the major Supreme Court ruling that was handed down yesterday. The majority conservative court has narrowed Section 2 of the Voting Rights Act, gutting the provision that helped to create so-called minority majority seats in Congress. This is something that we see a lot in the South, where very recently we obviously saw a huge swath of Republican-controlled districts. So these majority-minority districts were Republican and white districts, and these were sort of created to allow for those who were the minority in these majority districts to sort of have their own districts, to elect their own representatives.
Well, and most of the time we're talking about African-American voters.
Correct,
but even in some states like Texas, that could be Latino voters, Hispanic.
Yes.
So it is mainly constituted in the South, like you said. So we'll break down those effects here in a little bit as we continue on.
So this is going to have a big influence on how states draw their congressional maps, and the changes could be seen almost immediately. CBS's Christian Benavides has the details.
The Supreme Court struck down Louisiana's congressional map on Wednesday, and with it, part of the Voting Rights Act. In a 6-3 ruling, the court's conservative members found it was unconstitutional for lawmakers to use race to create this majority black district. Justice Samuel Alito writes, allowing race to play any part in government decision-making represents a departure from the constitutional rule that applies in almost every other context.
It means that if we go to court and we challenge lines, that what the state can say is, I wasn't considering race, I was considering politics, and I think that would be a very strong defense after this particular decision.
In a dissenting opinion, Justice Elena Kagan writes, the court's decision will set back the foundational right Congress granted of racial equality in electoral opportunity. Louisiana Governor Jeff Landry wouldn't rule out an immediate effort to redraw the map in his state, even though early voting for primary contests starts on Saturday.
The court decides to give it to us on the eve of the election. What are they telling us? Are they telling us we have to draw? Are they telling us we don't have to draw? Should we draw?
New York Democratic Congressmember Alexandria Ocasio-Cortez says a national ban on gerrymandering is the only way to stop the gamesmanship.
If Republicans are going to redraw North Carolina, if they're going to redraw Texas, if they're going to redraw and gerrymander every one of their states, then unfortunately we have to provide balance to that.
Shortly after the Supreme Court ruling, Florida Republicans took a step toward approving a new map that could net the GOP 4 extra seats. Christian Benavides, CBS News, Miami.
Yeah, so a very sort of generic breakdown of what was ruled, but then also sort of the immediate reaction that we're seeing, because we were already talking about congressional maps in the wake of obviously what Texas did with their redistricting, what California did as a response. But now we are potentially, after thinking that we were sort of coming to a bit of a close when it came to redistricting. We were hearing that in Florida, for instance, there were some signs and some calls to end the redistricting proposals because maybe this went too far and we were creating this potential advantage for Democrats, hearing this from Republican lawmakers. Now we're sort of seeing this reinvigoration of the conversation.
Yeah, it kind of seemed like and to kind of touch up on what you said and maybe even reiterate it to some sense, when we first saw the gerrymandering effort in Texas, it had a lot of Democrats on their heels, and what we saw in response to that was a really aggressive push. Of course, here, Prop 50 in California, we saw most recently Virginia narrowly pass a referendum on new congressional maps. We've seen some other proposals being floated around in Maryland. There was a state Supreme Court ruling in Utah that helped Democrats, and it kind of felt like Democrats were starting to gain the advantage on this, but this could be perhaps the biggest card that could have been played of them all. One that, as we said, and we kind of teased and we'll continue to tease until we get to it, is not necessarily a 2026 move. This is a 2028. This is a 30. This is a 32, a 34, and beyond. So
you heard the governor of Louisiana saying, I mean, they dropped this on our doorstep just before an election. Like, we have primaries that'll be going on here very soon in the summer, and then we obviously have the general in November. Will there be enough time with any legal, challenges that are likely to still even come despite this ruling to really redraw districts for the benefit of it? I only say for the benefit of Republicans because in Louisiana in particular, where this case was obviously the subject of the Supreme Court ruling, that is a Republican-controlled state legislature and governor.
Yeah, so how about we let's just dive right into it. Yeah. So I would say let's start off with some general background just to make sure that we all know what we're talking about here. Starting with the landmark piece of legislation that is really at hand here. And what we're talking about is the Voting Rights Act, specifically the Voting Rights Act of 1965. There's one of 64, one of 65. This one in particular, 1965. This was signed into law by President Lyndon B. Johnson. There's video of it right there. That's August 6th, 1965. Of course, a landmark piece of civil rights legislation. There you see the Reverend Dr. Martin Luther King Jr. standing by Johnson as he signs the legislation. Essentially, what it was meant to do was to enforce the 15th Amendment, which prohibited denying the right to vote based on race or based on color. You mentioned it in the intro to that package. There's a key provision that's really at the heart and kind of served as the true foundation, or one of the foundations, the last remaining at this moment, which is Section 2, which basically said that it votes practices or procedures that discriminate on the basis of race. Section 5, which was another foundational part, which had since been gutted, and we'll get into the details about how that became the case, previously required states with a history of discrimination to get federal pre-clearance before changing any sort of voting laws. The act, of course, has been amended several times. One of the most notable ones was in 1982 in response to a Supreme Court ruling that raised the bar for proving discrimination. So, of course, and this comes in the wake of Jim Crow and what at the time was just the latest iteration in a long line and a long evolution of anti-democratic, anti-voting practices that traditionally white majority states would inflict on Black Americans at that time, both before and after they earned their freedom.
Yeah, and we saw an immediate impact with this. Within months, hundreds of thousands of Black voters were registered across the Deep South. So again, you have to remember, this wasn't necessarily that people were voting, but they were just maybe not represented by who it is that they wanted. There was thousands upon thousands of cases of people being prevented to be able to vote. Well, then all of a sudden you had thousands of Black citizens who were now registered to vote across the Deep South that were still dealing with a lot of the repercussions of, obviously, as you said, Jim Crow era, segregation, and so forth. Well, federal examiners were sent to counties with history of voter suppression. Black voter registration in Mississippi went from roughly 6% to nearly 60% within just a few years.
And in some places, that's in line or above white voters at that time. Yeah.
It enabled the election of Black officials at local, state, and federal levels for the first time in decades. And I think, again, one of the best ways that I've heard this is that essentially there was a marathon that was going on, as an analogy, and white voters were 20 miles ahead of Black voters, and they were being held back at the start line. And now you gave Black voters the ability to now run the marathon, right? You held them back for years, but now they finally have a chance. They finally have a chance to get into the competition, to get into the game. And so that's why this was done, to try to correct some of the wrongs of the past. And so it really did allow for a lot of decades, a history of suppression and no representation to sort of be put on the back burner, so to speak, so that we could see representation of Black communities at local, state, and then eventually even the congressional level. For Republican majority states, the legal obligation to protect minority majority districts also meant protecting Democrat majority districts. And as in the South, Black voters tended at the time to be Democrats.
Yeah. So, and that's an overlap that has existed ever since then. And that's kind of that's the tease into the problems that we faced here and what kind of led into the decision. Because, of course, you'll hear even from the conservative justices who made this decision. This was a landmark piece of legislation, and it did a lot. Now, we'll go into why maybe they might not see it as necessary at this moment. But if you want to look at it strictly from the lens of a hyper-partisan viewpoint,
well, I would say
it does put Republicans at a disadvantage. Yeah. Because it just based off of the Democrats and the demographics and the voting history, you are essentially asking a Republican majority state to defend and uphold what would be something that politically and strictly politically would not be within their interests.
Well, I think it also mirrors what we saw happen with affirmative action not too long ago. Again, affirmative action was put in place because there was a suppression of allowing Black potential students into colleges and into jobs, and affirmative action was meant to help ease the burden of what was put on a community over trying to seek education, seek work, and higher jobs and things like that. The Voting Rights Act was put in place. A lot of this was put in place to, again, correct the wrongs of the past. And what you are seeing now is that there is a huge push from, as you pointed out, right now it's conservatives because they feel like they are politically helping out, the other side, so to speak, in order to protect this, when they maybe feel like this type of protection is actually doing more negative than positive. That's their argument.
And that's an important viewpoint that, like you said, is important, especially now at this time and going forward. So, of course, this was signed 1965. That was over 60 years ago. It has molded, it has evolved, and we're going to do a quick run through of not necessarily the evolution, but in some way, the defanging of this law, because it has lost a lot of legal prowess as the generations has came on. So we're going to run through this really quick before we start taking a break, Chris. In 1980, a court ruled that plaintiffs must prove intentional discrimination to win a Section 2 case. That is a high bar. Intentional discrimination, and we'll kind of get to how that is still going to be an issue going forward. That forced them to amend the law in 1982. That was less than 20 years later. In 1986, the Supreme Court established a test as to determining whether a district map was illegally diluting minority voting power. That's something called the Gingell's test. Essentially, it means three things. One, a minority group must be large enough and geographically compact to form a majority in a district. Two, minority voters must vote cohesively, that meaning the minority voters tend to historically in previous elections vote the same. And then three, in this case, the majority, but in this case, white voters must vote as a block to defeat the minority group's preferred candidate. Essentially meaning, when you look at gerrymandering, there's two different terms. There's packing and then there's cracking. Cracking is to split across votes so that they're so diluted that they can't do anything, or it's packing, which, usually means making sure that only one district has this political power while the rest are from your party. But in this case, it's saying, you are putting them specifically in this category so that they're all put together and their vote is rendered meaningless because you can always be trumped by the majority. But the real changes that we see that are really starting to make a difference were only within the past 15 years or so. So I want to talk about two in particular. In 2013, a Supreme Court case called Shelby County versus Holder. What this did is gutted that Section 5 pre-clearance, ruling the formula used to determine which states needed federal oversight was outdated. Of course, that being a district, a state, had a notable, tangible history of discrimination against minority voters. In this case, of course, we're talking about Jim Crow, and we're talking about the South, Reconstruction. We're talking about African Americans in particular here. That rendered that rule essentially meaningless, meaning that, it does not matter what happened in the past. Therefore, if you can't judge what happened in the past, you don't need the federal clearance because it's rendered null and void. So Section 5 then, as we said earlier, effectively became gutted. And then another one was just 5 years ago. What happened 5 years ago is the court narrowed Section 2 further, making it harder to challenge voter restriction laws. That meaning it is much harder to bring some of these cases to court. So the statute still existed, and there was still the ability to bring lawsuits forward, as we have seen, but it was much, much harder to do so at this case. And what's notable about this, too, is that this is part of the John Roberts Court, those two Supreme Court cases. So what we're seeing today is the third in a long line of different Supreme Court cases that have effectively narrowed further and further the legal teeth of the Voting Rights Act of 1965.
And this was, as we kind of continue here through the timeline, 2023 Allen v. Milligan. If you just want to kind of run through these here, in a surprise 5-4 ruling, Roberts sided with liberals actually to uphold the Gingles test. So they tried to keep in the test and to strike down Alabama's congressional map for diluting black voting power. So Alabama sort of threw out that first test.
They attempted to crack.
They attempted to crack. They attempted to throw out that first test of okay, maybe seeing the tea leaves here, the momentum of the Roberts Court. Where are we going to go with this? And surprisingly, Roberts actually sided with 5-4 with liberals to sort of keep the Gingles test in place. But we go into now Wednesday's ruling and effectively, again, set in Milligan just 3 years later.
Perhaps a very similar situation, but a completely different ruling.
Right. And again, the result that Alabama potentially was looking for. So, very complicated, obviously trying to break this down as best as we can. But if you begin to see sort of where the momentum was going, I think you use the phrase, and again, it's looking back to the past. If those wrongs don't exist now, I think what you're seeing is sort of this, in the minds of those who are challenging this, what they feel is like course correction, so to speak. That everybody's on a level playing ground now, so let's just get rid of some of these protections.
So you kind of did the perfect tease there. That is part of the thoughts that went into the decision. Of course, we're going to break down the decision and the arguments and the opinions from the specific Supreme Court justices, Chris. But first, let's take a quick 2-minute break.
All right, welcome back, everyone, into Right Now. We are going over the very latest Supreme Court ruling that was just handed down yesterday and how that impacted the Voting Rights Act and really the way that congressional districts are drawn, specifically with minority and majority districts. We went through the history of the Voting Rights Act, and how it has sort of been defanged, if you will. So let's jump into the ruling now, Jack, and sort of what it is that we saw. So this was a 6-3 decision along ideological lines. Majority written by Justice Samuel Alito, joined by Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett. The court struck down Louisiana's 2024 congressional map, which had created a second majority black district following a prior Section 2 challenge. The majority ruled that creating a district primarily because of race, even to comply with the Voting Rights Act, amounts to unconstitutional racial gerrymandering. Alito wrote that Section 2 must be read narrowly to enforce the 15th Amendment's prohibition on intentional discrimination only, not mere disparate impact. Now, the ruling dramatically raises the bar that plaintiffs must clear to win a Section 2 redistricting challenge, and the court stopped short of formally striking down Section 2, but critics say the effect really is all but the same.
Yeah, and you'll see that in a lot of Supreme Court cases. You know, stuff will still be on the books, but there's just no reason to really put it on. What's really notable, I would say, about that decision is the quote that you said there, which is, Section 2 must be read narrowly to enforce the 15th Amendment's prohibition on intentional discrimination only, not mere disparate impact. Essentially what that is meaning, and what a lot of legal experts are saying what this essentially amounts to, is any sort of racial gerrymander, whether it is to help minorities or to harm minorities in terms of their voting power. You essentially need to see whoever is drawing those maps go on a stage and say, we are doing this to make sure that black voters can vote less. Or we are trying to do this to make sure that black voters could vote more. Because if you're in a court of law and they're asking you, did you do this to help, African-American voters or Hispanic voters or Asian voters? They're going to say, no, I did this to help Democrats.
Yes,
and the opposite is the truth. We did not mean to do this to disenfranchise African-American voters. We did this to disenfranchise Democrats. That is a very powerful shield of plausible deniability, and
that
essentially
both sides could now wield.
Which both sides, and of course this is going to have effects on both sides of the equation. But again, you essentially need to either announce it yourself or get caught on a hot mic or get caught in internal documents. You know, literally a smoking gun in order to kind of have this be a legitimate argument in a legal case. So let's go a little bit more into the majority opinion here. I found it interesting that Justice Alito was the one to write this opinion, especially something of this magnitude. We mentioned the fact that John Roberts had voted, this court had been a part of two other cases that significantly reduced the power of the Voting Rights Act of 1965. And like you said, just 3 years ago, Justice Roberts was one of the 5-4 majority to uphold a lawsuit of, or was this, let me make sure if it was to uphold or to uphold the Gingell's test, which struck down an Alabama law that basically did the same thing. So this is very much a heel turn in a way that you're seeing from Roberts in terms of his judicial review on this. So you didn't see him issue not the main majority opinion here. So he argued, Samuel Alito argued that the lower courts had been misapplying the Voting Rights Act precedent in ways that forces states to engage in the very race-based discrimination the Constitution forbids, essentially creating a minority-majority district. He also wrote that under Section 2, a minority voter is entitled to nothing less and nothing more than freedom from intentional racial discrimination, argued that allowing race to drive district drawing is a departure from constitutional principles. So, essentially what we're getting at here is kind of what you mentioned, is that the Voting Rights Act, Samuel Alito would likely argue, was and he does, admonish Jim Crow and all of this stuff in there. But his point is that this was meant as a correction on the greater line of progress. And he believes that at this point, the Voting Rights Act of 1965 has served its purpose and that the course had been corrected. And now you're seeing it be used to not to necessarily enfranchise voters or disenfranchise, because he says that, the average African-American voter has does not deserve suppression of any kind, but to draw a map specifically for their political power is also bad. So that's what you're hearing from Samuel Alito and the rest of the conservative judges here. Some went even further. Clarence Thomas, who was joined by Gorsuch, wrote separately that he would want to see the court go even further. Of course, he's long held that Section 2 doesn't apply to redistricting at all, and that's a view that's now closer to mainstream within the conservative bloc here.
Yeah, we've heard a number of criticisms of the Voting Rights Act, especially, again, as we've seen this sort of wave of revisionism, as I would put it, towards both affirmative action. The Supreme Court has pretty much dismantled that. And now you have, obviously, with the Voting Rights Act. And a lot of that has come from the conservative legal scholars, such as Justice Clarence Thomas, and obviously with the Roberts Court as well, too. Many legal scholars on both sides would argue that we have seen sort of an erasure of some of the protections that have been put in place based on a lot of the reasoning that you just laid out there. Now, let's jump into the dissenting opinion. It was Justice Kagan who wrote the dissenting opinion, joined by Sotomayor and Ketanji Jackson. Now, they wrote a scathing dissent, called the ruling, quote, abominable, and said it renders Section 2 all but a dead letter. Argued the majority effectively reversed Allen v. Milligan, a case that we but discussed just a short time ago, that falls in the timeline of the Voting Rights Act, a case decided just 3 years prior that we told you about, that Justice John Roberts helped them rule on, formally overruling it, accused the majority of allowing states to dilute minority voting power by cloaking racial intent behind partisan justifications. Wrote the decision will, quote, will set back the foundation right Congress granted of racial equality in electoral opportunity. Noted that Roberts, who wrote the Milligan majority in 23, signed on to Wednesday's opinion without explanation for the reversal.
Yeah. You have a lot of pointed criticism here of John Roberts, essentially considering his prior judicial record here. And I want to quote another interesting thing that I heard today. Wasn't necessarily a quote from Kagan in her dissent, but one of the counter arguments we heard from a previous Supreme Court Justice, Ruth Bader Ginsburg, because this is, of course, some of those previous decisions in 2013, for example. Ruth Bader Ginsburg was on that court at that time. And she had
That's how you had enough votes. Yeah.
And she wrote at the time, just because it's not raining doesn't mean you don't need an umbrella. And so to kind of summarize what we're hearing here from Justice Kagan is essentially, just because you might think that this law had served its purpose, if you're taking it away, you're also taking away a disincentive for people to do the same thing again. Right. So that's the fear that you're hearing from there. Of course, again, like we said, the noted criticism towards Roberts. Also, no explicit mention of that previous Supreme Court ruling, Allen versus Milligan. I wonder, that was one of the questions I had when I was producing this, is there some sort of conflict of precedent there? That's something that you might have to, we might have to see answered a long time down the road in a
or
if
we've seen this in the past, where again, a Supreme Court justice rules one way in a case and then essentially nullifies their previous ruling in a future case. I'm not sure.
Yeah,
I wonder.
Or two dueling things that don't necessarily cancel each other out. They just both exist in the same space at the same time. Yeah. So that'll be a question for another day, I would say. But of course, this is all going to have major effects going on with the redistricting. I would say this is some of the most hyper-partisan times that a lot of people have probably experienced in their life. And I think that this mid-decade redistricting is just another clear example. It's exemplary way to discuss, to represent kind of the weird political times that we're in.
Yeah.
And now we're at a point where you're going to see some major consequences.
Redistricting doesn't normally occur unless there's a huge, some sort of event that affects the citizenship, but really until we start to begin to see census results. And we see, whether or not certain states will have the same amount of representation in Congress, and then sort of congressional lines are redrawn and so forth. But what happened in Texas, what happened here in California, what is being proposed across the landscape of the United States of America really does exemplify what we are seeing, which is hyper-partisan politics, as you pointed out. This is seemingly a race to stack the box, to try to put into place as much protection as you can, versus what traditionally, and some would argue that again, gerrymandering is we have everything in place right now because this has always been sort of a political strategy that's been used by both parties at separate times,
of course, yes,
in the history of the United States. But it just feels amplified right now.
You mentioned the census. Censuses, I don't know what the plural of that is. Beside the point. That's done at the end of each decade.
Sensei.
Sensei. It's done at the end of each decade,
Yeah.
and that census is then applied to the following decade. So in 2020, the census was conducted, and that affected the appropriation of House seats, and so on and so forth for the rest of the 2020s. Why this is notable and why this is like the poster child for hyperpartisanship is because a mid-decade redistricting is something that that is incredibly rare. To my knowledge, there's not any example in recent memory of this being done. Of course, this got kicked off when President Trump asked Texas to redraw their maps. An unprecedented level of hyperpartisanship and of the drive, the political tit for tat of consolidating power. It is taking a practice that has been condemned but widely used for a long time, and it is cranking the dial to 11. And after we take a break here, we're going to dive into what dialing that up to 11 is really going to mean.
Yeah, so let's go ahead and do that. We'll go ahead and jump into that, as well as the impact, a potential impact here on the 2026 midterms and beyond, the short and the long term, when we get back. All right, welcome back into the Right Now studio. Jack and I have been discussing the impact that the very latest Supreme Court ruling could have on voting rights here moving forward, redistricting. But now let's sort of look at this through the political sort of warfare landscape, if you will.
Yeah. So we ended the last section by talking about the mid-decade redistricting and how that has kicked off one of the most, I think if you care about voting rights, it's absurd on both sides, because what you are essentially doing is they are politicians picking the voters rather than the other way around. That's why this is such a debated and such a controversial practice. Of course, both parties are doing it at this point, and it really is just a chess game of who can amass the most power going into 2026 and potentially 2028, as we've seen some of these Democratic measures go beyond just these midterm years. The Prop 50 goes until 2030 before you start to see some changes. But let's talk about 2026 first. The practical impact is kind of unknown at this time, and there's a wide spectrum of outcomes that we can see here. So it's kind of hard to put a finger on it, but we want to just talk about different states. We want to talk about different scenarios in which we might be able to see some stuff. We know that there's about a dozen Black or Latino districts that could be targeted throughout the South, but let's start with the one at the heart of it, Louisiana. This morning, this is breaking news. We're breaking this. The Washington Post had an exclusive that said Louisiana's Republican Governor Jeff Landry told GOP House candidates that he plans to suspend next month's primary elections so that lawmakers can withdraw congressional maps. There was a question as to whether this would be able to take effect. I don't think that there is still a clear and cut answer, because, you're thinking about the timeline. You are just over 6 months away from these November general elections. Those are primary seasons. Those are filing seasons. All of these moves that you're going to make is going to expedite some of these processes. So whether we see that to be, plausible or not still remains to be seen. We know that I believe May 16th was the day in which that Louisiana primary was supposed to take place. So a last-minute delay, to say the least. Representative Cleo Fields, a Democrat, his district is at the center of that Supreme Court case. He argued it was too late for a new map and that redrawing would invalidate voter choices already made during qualifying. Also, it would ice him out of this election. Moving on to Florida. Florida had already unveiled a new map. Florida right now has a 20-8 Republican to Democratic advantage. If these new maps were to pass, these were just approved, I think yesterday, I want to say. I think this was a bang kind of like two-piece news cycle in terms of the Republican redistricting side. It would take away 4 seats, so that 20-8 Republican majority would be a 24-4 Republican majority. This one might not be as easy as other ones, because there was a constitutional amendment that was passed in Florida's constitution that talked about fair redistricting practices. So this one we might have a harder time. It just depends on whether this is going to be, taken to the Supreme Court in Florida or in, the federal government.
And with the timing of all of that.
And the timing of it. But they were essentially primed for this. Some of these maps that we're seeing were put with this case in mind. Mm-hmm. Sometimes they were just waiting for Pandora's box to open before they went ahead with them. So Florida's another one to keep an eye on. South Carolina was another one to keep an eye on. Republican gubernatorial candidates were calling on state lawmakers to pursue redistricting, immediately follow the ruling. We also saw Tennessee's governor try to galvanize state lawmakers to do the same. There's a minority-majority district in Memphis. That is one of those states in which you could see some potential diluting, or if you want to use the gerrymandering term, cracking. So you're taking that one, you're spreading, if you're in Memphis and it's one district and you have 5 surrounding it, essentially what you do is you just bleed that district into those 5. So you have 80%, if it's 80% black voters in Memphis, you take 20% and you put them in each district. Therefore, it is a black minority in that case. So those are the things that you're starting to see some calling on. Again, this is so late in the game, if we're talking about an election cycle, that the plausibility of some of these are completely unknown. This is going to require expedition in the courts. This is going to require perhaps changes to how, Texas, for example, they already did theirs, but their election calendar is so early that would be impossible if they were to do it now versus last year. So it just depends on the state cycle. We saw Louisiana delay it. So a lot of unknowns at this time, but plausibility, I think, is the key word here going into 2026.
Well, you mentioned expediting. There is a mechanism for that. And what this is that, so when SCOTUS hands down a ruling, it's not immediately sort of like, that's the law today. It takes 32 days normally to be finalized after issuance. Lawyers, though, in the Louisiana case, immediately ask the court to expedite that process. So that is a mechanism that they have. Responses to the expedition request are due by April 30th, which of course is today, at 4 p.m. Eastern, which is in about, 3 hours, a little bit more than 3 hours from now. The court could act quickly. Now, for states like Florida and South Carolina, legislatures could potentially pass new maps within weeks if politically motivated. Again, Florida approved these new congressional maps 16 hours ago. For most states, major redistricting will likely happen in anticipation of the 2028 elections, not 2026. Of course, the real impact is this ruling will shape redistricting drawn after the 2030 census. We're going back now to the impact of the census, giving Republicans a structural advantage potentially for the entire decade.
And that's key there, because that was
yeah.
already a boogeyman for Democrats.
Well,
That was
because they
already
were already
lurking.
Yeah, they were already looking at just the actual, regardless of redistricting, gerrymandering, they were already looking at cases of, for instance, California, New York, traditional Democratic strongholds where there have been extenuating factors that have led to a reduction in citizenship, a reduction in the population. So
in states
New York,
like Texas,
states
like
have
Florida,
gained, right? So it's
gains,
sort of a double. It's a 4-shot swing, and in terms of golf, it's more than just you potentially are going to lose House seats. It's that Republican states have now potentially gained that population, gained those seats,
and not just House seats, electoral votes. Because
yes.
I might not have this completely correct, but essentially what it's doing is if you were to the Democrat path to victory in presidential politics for the past decade or so has been the blue wall,
the
blue wall, the 7 swing states. So when you talk about you're talking about your Minnesotas, Michigans, Ohio's, Pennsylvania's, North Carolina, New Mexico, Arizona, Nevada, some of these key states. Well, if Kamala Harris won the blue wall in 2024, but it was with what is projected to be the 2020-30 Electoral College, she would not have won the Electoral College.
Right.
That path is becoming narrower. So you're going to find themselves in a situation where it's going to be harder to win the presidency. It is going to be harder to win the House. The Senate is still in play technically, but that has been, for the most part, a Republican stronghold for, I think, the majority of the time that you and I can remember. So, they're facing some real headwinds going forward. And it is going to require a complete retooling of the political calculus to thrive in there. We don't know what that's going to look like yet. But again, just another major challenge, and this is not expected to make that any easier. If you are a Democrat, that is something that you are sweating about, even now here, with it being, 4 or 5 years away. So what are Democrats doing about it? What is there that they can do? Because that's the real question. Of course, the immediate action is a legislative response. Again, these are just ideas. We don't know. This is so fresh. We're not going to be able to really see what is being done yet. Congress could theoretically amend Section 2 and to put in provisions that make it more stringent. State-level litigation. There are times in which that could be more effective. We were talking about the Florida maps. It might be more effective in that case to litigate on a state level than on a federal level. And I think that's likely what we're going to see there in that Florida case. It might even be successful in striking those down. We don't know yet. Of course, equal protection challenges. That's going to be some stuff we can see. Also, the other thing is more gerrymandering. This gives them a incentive to continue fighting this battle. You could essentially, the states like Maryland have failed in their maps. Will they try again? We heard J.B. Pritzker say, we have options. Illinois is already a state where it is disproportionately favoring Democrats. That could go even further. You could theoretically, you could divide all of Chicago into all of the districts. It would be a weird looking map, but that is hypothetical. So are we going to start to see these hyper partisan maps amplify even more? And of course, political messaging. Democrats have done I think the polling suggests that this is something that, even regardless of the redistricting battle, is expected to be a very good year for Democrats in the House as things stand right now. There's even I even read some articles, some Substacks talking about how even in some of these redrawn red areas, you might see some at play here, albeit it might be difficult.
I
but
believe that was in Texas, right?
Texas is one of those examples.
Because the gamble that they made in Texas was that the huge swing, and I know that we got to wrap this segment up, but it is very interesting because President Trump has often bragged and talked about the gains that he made when it came to Latino voters. Well, in Texas, they attempted to sort of capitalize on that in the double-digit gains that they made. However, a lot of those gains have since been erased. And so what happens when that Latino voter group potentially goes blue? Now do those redrawn districts now all of a sudden sort of work against you? So there's always a double-edged sword when you're talking about redistricting based off of one presidential election and sort of increases in voter blocks that you may have received and what may have just been an outlier in terms of support from one group.
To summarize, they tried to turn a solid Democrat into a lean Republican, but they essentially might get either lean Democrat or a toss-up as a result. Perhaps not the result that they wanted. And that's going to be another thing because you are going to see more Democratic voters in some of these Republican races. And we are seeing a large swing to the left in some of these recent elections, 10, 20-point swing. So, how effective is this going to be in the short term, even with redrawn maps? Who knows? Because there is a political motivation on the Democratic side right now, which could have the potential to still shake things up.
I think we essentially what we might see is even more hyper partisan politics.
That is for sure
at play, especially when it comes to who it is that you even have the ability to vote for.